Hello everyone, and welcome to the McInnes Cooper webinar entitled #It's Time, a 5-step sexual harassment risk mitigation strategy for employers. My name is Brad Proctor, and I'm a partner in McInnes Cooper's Labor and Employment Group. I practice in the areas of labor law, employment law, human rights law, and occupational health and safety. And those are all areas that are involved when we're dealing about the topic of sexual harassment. I'm going to hand the microphone over to my co-presenter today for her to introduce herself.
Good morning. I'm Katie Roebothan, a lawyer with McInnes Cooper in Halifax with a practice that focuses on all areas of labor and employment law. Specifically, I have experience advising clients on human rights issues, occupational health and safety issues, and have been involved in a number of different cases where allegations of sexual harassment have been made, investigated, and dealt with.
So we're starting today talking about workplace sexual harassment, and we would be remiss if we did not start with a reference to the Me Too movement, which has placed this issue very much at the forefront of Canadian, American labor and employment laws, as well as in the media. To start with, workplace sexual harassment is not a new topic. It's been around for decades now. If we trace its history in Canada, we can go back to a seminal case from the Supreme Court of Canada, which the facts of the case arose in 1982. The decision from the Supreme Court of Canada didn't come out until 1989, but it was a case that occurred in the hospitality restaurant sector in Manitoba, and it was the Jansen versus Platy Enterprises case. And it was a case where some female restaurant employees were being sexually harassed and filed a human rights complaint. It went through various levels of court, and quite surprisingly, at some levels of court, it was found that that was not in fact discrimination. But by the time it got to the Supreme Court of Canada, the Supreme Court of Canada confirmed that such acts fairly fall within the meaning of sexual harassment and sexual discrimination under human rights statutes. The Me Too movement has moved very quickly. If we think back to the events that started this movement, it was just in the fall of 2017, the October-November time period, involving the US media mogul Harvey Weinstein. And it's moved very quickly, and there's been a number of other incidences that have received high-profile media attention, both in Canada and the US. It's also led to another movement, which is the #TimesUp movement, which is a more formal movement, which is actually galvanizing legal funds to assist people with the prosecution of workplace harassment claims. And as well, I believe it has in excess of 200 pro bono lawyers signed up to support that movement. What we're going to talk to you about today is a 5-step risk mitigation strategy. And we're going to review each of the 5 steps in detail, but just to give you an introduction of what the 5 steps are. Step number 1 is for you as an organization to admit that as good as your organization may be today, it can and probably has experienced sexual harassment in your workplace. As we go through this seminar, you'll see that no industry and no organization is immune. The second step is to make it a high priority in your organization. It's not simply an answer of adopting a written policy. It's something that needs to be knitted into the fabric of your organization at the top end as a corporate governance matter and in your core values. The third step is to assess your risk in your industry and your specific workplace with respect to sexual harassment. The fourth step is to adopt, develop, revise your policies and procedures with respect to sexual harassment. Many of you may have policies and procedures, but question yourselves as to when's the last time you've reviewed them, and question as to whether the procedures thereunder are clear. And as well, along with step number 4, is the training of your supervisors and managers with respect to the policy, and the training of your workforce in general with respect to the policy. And lastly, the 5th step is to document and maintain records. So with respect to the first step, you'll see that it's something that can happen and likely has in your particular organization. and a head in the sand approach is simply not sufficient. If you look at media releases, or if you look in legal databases, you will see that no industry and no type of organization is immune from cases of sexual harassment. Just going on websites such as CanLII or other legal databases, you'll see that in public sector organizations, schools, universities, crown corporations, government departments have all had sexual harassment incidents. And if you look at the private sector, everything from large banks to industrial manufacturing facilities, large and small companies, and even technological startups have experienced sexual harassment. So it's not something that your industry or organization is immune to. As well, with respect to the head in the sand approach, employers need to be better at responding to sexual harassment. And I think as employers, many employers are very well equipped to deal with some of the more overt incidents of sexual harassment where there's been a formal complaint, and they do that through an investigation and potentially discipline. However, when it comes to some of the more covert incidents of sexual harassment, that's where employers need some more training. And when I talk about the covert, it may well be that you have a person who perhaps may simply be ignorant of the laws or ignorant of the manners in which is acceptable in today's workplace, or you could have a perpetrator who's deliberately trying to subvert workplace rules. And so that's why, as we go through our tips, we need to have up-to-date policies, we need to have workable procedures, we need to have awareness of our policies and procedures and what's acceptable, we need to have training of what's acceptable and how to enforce the policies, and we need to have mechanisms in place for reporting. When we talk about industries that are affected, I'm leading off with the photo here of Mr. Harvey Weinstein, as this industry was the industry that effectively started the Me Too movement. One of the things you'll see about these cases, and whatever industry is, it often involves a power imbalance. And of course, in Mr. Weinstein's case, his acts of sexual harassment were not only perpetrated against persons within his own organization, but also other organizations that dealt with Mr. Weinstein. So it may well have been another agency or organization whose employees dealt with Mr. Weinstein, and there's an obligation on those organizations to similarly protect their employees from those types of interactions as well. We can look at this industry. It wasn't that long ago in Canada, in 2014, where the Jean Ghomeshi matter occurred, and that was primarily off-duty conduct. But once again, when I speak to the covert aspects of that case, it had come out in that case that Mr. Ghomeshi was bringing lewd text messages to work, photos and videos of some of his sexual escapades, and showing those to his supervisors in the CBC workplace. So some of the covert issues, had there been proper training, were coming up in the workplace in that case. And this happens in this Weinstein matter in the US in 2017. If you look online, you'll see in Nova Scotia in January and February of 2018, groups such as Women in Film and Television Atlantic were doing seminars and training sessions in January of this year with respect to some of the very issues that were being complained about in the Weinstein matter. We go on to the industry, the next industry of hospitality. And the reason why we show this is it continues the trend of the power imbalance. I mentioned the Supreme Court of Canada case. That's the facts occurred in 1982 and the case came out in 89. That was the Jansen and Plady case. That was from the hospitality industry. And there's quite a staggering statistic about the hospitality industry. In a 2018 Harvard Business Review report entitled Sexual Harassment in the Restaurant Hospitality Industry, it has the highest rates of incidents of sexual harassment in the US of any industry, with 90% of women surveyed claiming that they've been sexually harassed. So there's an industry, once again, it could be power imbalance from owners or managers in the restaurants, or servers and whatnot interacting with customers. As I've mentioned, it doesn't have to be, it can be large organizations, small organizations, new age organizations, such as the IT startups. And here's an example of a US example involving the IT industry. And of course, it goes without saying, perhaps if we call it an industry, the area which perhaps has garnered some of the most media attention has been politics. Here we have photos of Roy Moore, George Bush Sr., and other famous U.S. Politicians as putting that front profile. And not just U.S. politics, but as well, we have the examples in Canada of the Ontario Member of Provincial Parliament, Patrick Brown, Calgary MP, Ken Hare, and of course, back in Nova Scotia, our PC leader, Jamie Bailey.
So recent survey results show a very high frequency of incidents of workplace sexual harassment and violence. On February 8, 2018, the Angus Reid Institute published the results of its new survey of Canadian public opinion, Me Too, Moment or Movement. And according to this report, 52% of women and 22% of men surveyed said that they have been sexually harassed. And 28% of women and 14% of men have also experienced non-consensual sexual touching or sexual harassment at work. Moving backwards in time a little bit, a December 2017 survey by Insights West concluded that 54% of working women in Canada say that they have experienced conduct, comments, gestures, or contact of a sexual nature that caused them offense or humiliation. And then moving backwards in time a little bit earlier, in November of 2017, the Federal Minister of Employment and Social Development Canada published its report, Harassment and Sexual Violence in the Workplace, What We Heard. And this report revealed that 30% of online survey respondents, approximately 1,000 of whom identified as female and 200 as male, said that they had experienced sexual harassment. So interestingly, the incidence of sexual harassment and violence are quite a bit lower in this November 2017 report, as opposed to the two more recent reports from December of 2017 and February of 2018. And this is likely explained by the fact that this November 2017 report was issued just after the allegations against Harvey Weinstein broke. In the more recent survey results, we are seeing the impact of the Me Too movement on women's willingness to speak up about sexual harassment. So the results of these reports also confirm what many people already believed. Women aren't the only targets of workplace sexual harassment, but they are the primary target. So referring again back to the report from the Angus Reid Institute from this past February, it revealed that 52% of Canadian women said that they've experienced sexual harassment and 28% non-consensual touching, compared to 22% of Canadian men that said that they've experienced sexual harassment and 14% who claim that they've experienced non-consensual touching.
So now that you've admitted or perhaps accepted that this is something that could affect your organization within your industry, the second step is to determine what level of priority this is going to be within your organization. And there are a number of issues that we deal with as organizations that we tend to place to the top of the priority list, depending upon our industry. And we're suggesting that this is one that should be placed at the top of the pyramid. In fact, we're not here advocating that you simply draft a policy, put it on the shelf, revise your policy. We're suggesting that you make this part of your organizational culture. And when I speak about culture, I'm speaking about the small c culture, which is the culture which is unique to your organization. And in order for that to happen, in our view, it's got to be it's got to be very top down. And so many organizations have different things that they adopt, such as vision statements, mission statements, and often underlying those vision and mission statements are organizational values or core values. And that's where we're suggesting that things such as respect and equality are in the organizational fabric and led from the top down by your board of directors, if you have one, your executive management team. And that's what you need to have this kind of fully endorsed throughout your culture. So for example, some tips or suggestions that we can offer from organizations that we've worked with or best practice examples are for your board of directors or senior level leadership team to make this an area of focus. Secondly, to actually have education for that top level executive team, that top level board, so that they are aware of the importance of this and obviously aware of the issues, and so that they are culturally aware of the importance in society and the legal risks associated. When you get a step down from your board or senior leadership team, to ensure that your managers and executive level employees are also trained, and their training has to be a little different from the training that goes to the board. Their training has to involve training on implementation and execution. We think that this type of policy should be a top of mind policy, which is simply not drafted and put in your policy manual or on your policy intranet. But it's something that needs to be reviewed annually. You may not review other policies like a travel policy annually, but this is the type of policy that should be put on your board's risk management matrix and reviewed on an annual basis. We also think there should be training for your employees to let them know that there are policies, there are rules, there are procedures, and there are consequences. And after you've done that training, there needs to be refresher training so that it's constantly on people's mind that these policies and procedures exist. And of course, when there are incidents, they need to be dealt with and enforced. And there should be a feedback loop on an annual basis back to the board each year about the usage of the policy and its implementation, and that can go into future revision and future drafting. Some of the things that the risks that we need to make people aware of when it comes to this is there's really a multitude of different types of risks and different types of legal fora, if you will, that people can bring these types of complaints. So the first you'll see is occupational health and safety. In every jurisdiction in Canada, employers have a legal obligation to ensure a healthy and safe workplace. And that is virtually the same in every organization in Canada. We call that a general duty. And so that's the same for everyone. And in our view, things such as sexual harassment, you're in breach of the general duty to provide a healthy and safe workplace if you don't take steps to manage those things. However, some jurisdictions, some more specific than others, specifically legislate in their act specific issues with respect to sexual harassment. Ontario, for example, would be one under their occupational health and safety legislation. We then have human rights legislation. And once again, every human rights act in Canada prohibits discrimination on the basis of gender and sexual harassment. And Nova Scotia is one of those jurisdictions. Nova Scotia specifically defines sexual harassment in its legislation and specifically prohibits that. So an individual could complain to the Nova Scotia Human Rights Commission with these types of matters. Employment standards legislation. Some jurisdictions in Canada deal with sexual harassment differently than others. However, in every jurisdiction in Canada, if you don't provide a healthy and safe workplace, that can form the basis of a constructive dismissal. And in Nova Scotia, our employment standards case law does recognize that concept. The criminal code, when we're talking about sexual harassment, there's an array of misconduct, if you will, or wrongdoing, which can be, on the one hand, verbal comments, but on the other hand, can be assaults and touching. And it's always important to remember that these things are also prohibited by the Criminal Code of Canada. So individuals who are sexually harassed, sexually assaulted, do have rights under the Criminal Code of Canada and can raise those matters with the police, and that could lead to criminal prosecution. We also put a question mark next to this one, and the question mark is not on the basic things such as criminally prohibited sexual assault, but on Section 217 in particular. People will remember that back in 2004, the Criminal Code of Canada was amended to insert Section 217 out of the Westray disaster that occurred in Nova Scotia in 1992. And that was primarily intended to criminalize health and safety related offenses. We don't yet have cases in Canada that have criminalized situations where employers have not adequately managed and prohibited sexual harassment in the workplace. So we put a question mark there to say that that is a possibility. Of course, employment contracts, cases of, once again, constructive dismissal, wrongful dismissal, it's implied in everybody's employment contract that employers are going to provide a respectful workplace. And if we do not provide a respectful workplace, that can lead to a claim, an allegation of constructive dismissal. And lastly, in a unionized workplace, once again, there's All of the legislation I've mentioned, occupational health and safety, human rights, employment standards, are deemed incorporated into the collective agreement. So even if our collective agreement doesn't address sexual harassment, the laws on it are deemed incorporated into our collective agreement. And when it comes to the specific types of financial risks that you could face, I've listed them there on the right-hand side of the slide. When you have cases such as this, there's often significant monetary compensation. And there's all types of risks we're going to talk about, but I'm going to focus here a little bit on the financial piece for a moment. These types of cases can involve past wage loss. So if someone's been out of the workplace and hasn't been able to work as a result of sexual harassment, they can make a claim for past wage loss. They can make a claim for future wage loss. They can make a claim for general damages. General damages is the type of damage that's given to someone for the infringement of their human rights and human dignity. There can be specific losses, so specific what we'll call quantifiable losses, medical expenses, counseling, things of that nature. There can be aggravated damages and punitive damages, which is a tribunal or a court's way of saying, employer, you didn't do enough and we're going to punish you for this with an award of damages. In addition, we'll talk a little bit later about other types of risk, but I just want people to be aware it's not just financial risks. When you go to human rights tribunals, for example, with respect to claims of sexual harassment, there could be other remedies such as training for boards of directors, training for organizations, policy reviews, policy adoption. There could be apologies required. Of course, Katie in a moment is going to talk about some of the reputational risks of these types of matters. With respect, of course, to matters under the criminal code, we do also note that there is the possibility for jail time for perpetrators of sexual assaults that violate the criminal code. I also mentioned that there was a number of different avenues for individuals to proceed with complaints of sexual harassment. And you'll see I've listed a number of them in yellow boxes. And the one at the bottom, the orange box, I want to talk a little bit more about in detail. But effectively, under our internal harassment policies, people can file an internal complaint. They don't have to just keep it internal. They can go external and they can file a complaint to either the human rights regulator, the occupational health and safety regulator, or the employment standards regulator, depending upon the legislation in your jurisdiction. In a unionized workplace, they can proceed with a grievance under the collective agreement. And of course, if it's a criminal matter, they can file a criminal complaint. But one of the newer trends that we're seeing rising out of the Me Too and the Time's Up movement is the civil lawsuits. And in fact, I've heard and read a number of recent articles and news events by both American and Canadian lawyers that is one of the preferred ways that they're advising clients on how to proceed with these. For example, there's a January 8, 2018 CBC interview and news article online arising out of a lawsuit against the Soul Pepper Theatre in Canada that says civil lawsuits for sexual harassment, a new avenue for women. And there's a number of reasons for that. But what we're seeing is if someone goes to the police with a complaint of sexual assault, then the police are going to investigate that. The police are going to hand their file over to the Crown prosecutor, and the Crown prosecutor may lay charges, may not lay charges. The charges might get filed. There could be a plea arrangement. That whole process is entirely outside the control of the complainant. Whereas when it's a civil lawsuit, the civil lawsuit is entirely controlled by the plaintiff. So the drafting of the pleadings, how fast the case goes, how slow the case goes, whether it's settled, whether it goes to court, those are all matters of which the complainant has control over. Of course, on the criminal perspective, to prove someone guilty of a sexual assault, they have to be proven guilty beyond a reasonable doubt. So, effectively, I always say 99% certainty, whereas in a civil claim, you only have to prove someone wrong on the balance of probabilities. So that's effectively 51%. So there's a lower burden of proof. In a criminal process, the alleged perpetrator has the right to remain silent. And in many cases, and in most cases, does not take the witness stand. And the complainant or plaintiff or victim has no ability to question that person in the criminal process. In the civil process, there are multiple opportunities to question the alleged perpetrator, either through the discovery process, through documentary disclosure, and ultimately a trial. As I mentioned, there's much greater control over the process. And in the criminal, the remedy in a criminal matter is most often, it could be jail time, it could be some form of probation. However, in a civil setting, the remedy is often financial compensation, which can be all of those monetary items that I listed on an earlier slide.
So in addition to the direct monetary consequences that Brad's talked about, there are also business risks and related costs to employers that don't deal with sexual harassment properly. So first, there's a large risk of reputational damage. In today's world, with the Me Too movement and with social media playing such a big role, harassment victims are taking to publicly naming and shaming the alleged harassment perpetrators, and as well often naming and shaming their employers. Legal actions, as we know, can be highly publicized, and workplace sexual harassment cases often are highly publicized. Civil court proceedings are public, human rights boards of inquiry are public, and therefore sexual harassment can cause employers immense reputational damage, and flowing from that, often more severe financial consequences. So for example, you have a company named after its founder. The founder is alleged to have engaged in sexual harassment, and these allegations go public. What happens to this company? Well, in October of 2017, the allegations against Harvey Weinstein broke. They were made very public. And as a result, the company went into bankruptcy. And just recently, the company sold, but for a very, very low price. And all of this happened over a period of months. So this just goes to show how significant reputational damage can really be. And there are also opportunity costs. Workplace sexual harassment and harassment complaints cost management time. For example, it takes time to respond to and to investigate complaints of sexual harassment. Harassment complaints also have a very negative impact on targeted employees, their coworkers, and their managers, impairing motivation, productivity, and causing lower morale. Therefore, effective prevention and response to sexual harassment reduces turnover among employees, and it fosters a more productive and a healthier working environment, all of which can create cost savings for an employer. So, occupational health and safety laws in some provinces expressly require employers to undertake a risk assessment in relation to workplace violence. Now, the legislation in some provinces also requires employers to undertake assessments in relation to workplace harassment. Now, regardless of whether a risk assessment is expressly required by law, it's still best practice to undertake one. So first of all, in carrying out a workplace risk assessment, you should consider involving workplace stakeholders to participate in the risk assessment process. So for example, the Occupational Health and Safety Committee or representative in your workplace. And you should also consider engaging third-party experts or legal counsel to help conduct and validate the risk assessment. In conducting a risk assessment, it will also be helpful if you have a risk assessment checklist to guide you. Government departments like provincial occupational health and safety agencies often have online risk assessment checklists that will be of assistance. And also, in conducting the risk assessment, you want to assess risk factors that are specific to sexual harassment and violence. A number of industry organizations and regulatory bodies make these types of risk factors available. So for example, the November 2017 report that I spoke about earlier in the presentation from the Employment and Social Development Canada, entitled Harassment and Sexual Violence in the Workplace, What We Heard. Now this report details the top risk factors survey respondents identified for workplace sexual harassment and for sexual violence. And finally, as part of the risk assessment process, employers should also consider what steps they've taken to mitigate the financial exposure in the event of a workplace sexual harassment or workplace violence complaint. For example, employers should carefully assess their situation with their insurance broker. Insurance coverage for workplace sexual harassment claims by employees and others against the employer, its employees, directors, and officers is often available and recommended. Now, as Brad mentioned earlier, the importance of having a workplace harassment policy. A well-drafted, effectively implemented, and consistently enforced workplace harassment policy is the key to managing, reducing, and hopefully preventing workplace sexual harassment. So if you don't have a workplace sexual harassment policy, or if you have a workplace sexual harassment policy in place, you want to review it, you want to revise it, and you want to keep it updated. If you don't have a workplace sexual harassment policy, you want to develop and implement one as soon as possible. So when drafting a workplace sexual harassment policy, employers can benefit significantly from consultation. So this includes consultation, a legal consultation and advice, consultation from harassment experts, and also consultation with workplace stakeholders, such as occupational health and safety committees and representatives in your workplace, and also consultation with the union if you operate in a unionized working environment. Now, when reviewing a sexual harassment policy that you might already have or drafting a new one, there are certain elements that you want to pay particular attention to. So, very important in any sexual harassment policy is that you want to make sure that the term sexual harassment is properly defined and understood. So generally, sexual harassment is improper conduct, conduct being acts, comments, or displays of a sexual nature that the perpetrator knew or ought reasonably to have known were unwelcome or would cause offense or harm. Now, it doesn't depend on the intent of the perpetrator. The focus is the effect on the target. And sexual harassment can take numerous forms. Examples of sexual harassment can include verbal abuse or threats, sexually oriented jokes, derogatory or patronizing name calling, comments of a sexual nature about somebody's weight or somebody's body shape, a display of sexually offensive or pornographic material, unwelcome invitations, requests, or sexual advances, unnecessary and inappropriate physical contact, and sexual touching or physical assault. Decision makers usually require that in order to constitute harassment, there be a series of different incidents, but that's not always the case, and one incident can be enough if it is severe and if it has a lasting impact on the target. So you just want to make sure that the term or the phrase sexual harassment is clearly defined in your sexual harassment policy, so those to whom the policy applies understand what sexual harassment is. You also want to make sure when drafting a sexual harassment policy that the term workplace is understood and properly defined. So the workplace is much bigger today than it used to be. The huge increase in the use of technologies like computers and smartphones have greatly changed the scope of the traditional workplace and also of workplace sexual harassment. So work is no longer confined to the time spent at the actual workplace. Work includes working from home, working remotely, instant messaging, business trips. So as technology has increased our ways of communicating, it has also increased the ways in which individuals can engage in sexual harassment. Any conduct that would amount to sexual harassment in person amounts to sexual harassment when done digitally. So for example, displaying screensavers or desktop backgrounds featuring offensive content can constitute sexual harassment. Also, many times, sexual harassment, whether in person or digitally, occurs outside of working hours and outside of the workplace, outside of the employer's premises. It's well established in law, however, that employers have the ability to discipline employees for off-duty conduct in certain situations. So, for example, employers can discipline employees for conduct that occurs outside of working hours on company property, like having drinks in the office lounge with coworkers on a Friday evening after work. Employers can also discipline employees for off-duty conduct that is both outside of working hours and off-site, but in specific cases. So for example, an employer could discipline an employee for conduct that occurs at a summer office party, at an employee's house, on a weekend, if the conduct harms the employer's reputation or product, if it renders the employee unable to perform their duties satisfactorily, if it leads to the refusal, reluctance, or inability of other employees to work with the employee, if the employee has been guilty of a serious breach of the criminal code, making their conduct injurious to the general reputation of the employer and its employees, or if the employee's conduct makes it difficult for the employer to properly carry out its function of efficiently managing its works and directing its workforce. And also, as you'll see, the third yellow circle on the slide, employers can also discipline employees for off-duty online activities, like sexting an employee or making comments on social media that include other employees in the communications, if this conduct detrimentally affects the employer's legitimate business interests.
So one of the things that I've observed in practice, and I will say that in light of the Me Too movement and the Time's Up movement, I do feel that many employers and clients are revisiting their policies and procedures. And I will say, I believe there's also been a more increased incidence of complaints. And I think most workplaces and many employers have very good prohibitions on sexual harassment in the workplace. Where I see area for improvement is in the procedures. Many workplaces in their employee handbook, company handbook, they'll have a policy that says we don't tolerate sexual harassment, but it stops there. It does not say what they're going to do and how they're going to deal with it. And so with respect to a policy, there are, of course, legal parameters of what is legal and what is not, but a lot depends on the actual drafting of your policy and the procedures that you draft and incorporate for your particular workplace. And that's where I see a lot of policies lacking. And when they are lacking in the procedures, that creates a great deal of stress for the complainant because they don't know how it's going to be dealt with. It creates a great deal of stress for the respondent as they don't know what the process is. And I can tell you, the human resource representatives and employer representatives that call me often have some anxiety in struggling with how to deal with the issue as well. So some of the things you need to think about from a procedures perspective is what is the complaint procedure and to whom does it go? Is there a form? What type of information are you asking for? Are there steps? Is there timing? Is there an informal option? Those are some of the things that you should think about. And what if a complainant doesn't come forward? What if a witness observed sexual harassment and brought that forward? Is that a complaint? Can an employer address those things? Those are some of the things that you need to consider as part of your procedures. With respect to investigation, I refer you, we've done on our website, we have done papers and seminars in the past on proper workplace investigations and have a paper entitled 5 Key Steps for a Proper Workplace Investigation, which you can access on our website. However, when it comes to investigation procedures, one of the things that we try and guarantee is confidentiality as best we can, recognizing that obviously complainants will speak to support people and we're going to have witnesses interviewed, but the confidentiality guarantee as best as possible is one. Question yourself as to whether it's appropriate to do an internal investigation or to retain an external investigator, and in what circumstances you might retain an external investigator. What is someone's obligation to cooperate with an interview if asked to be interviewed? How are we going to deal with issues if the complainant does not want an investigation and the complainant does not want it to go forward? As well as the communication once the investigation is complete. What are we going to communicate? Are we going to communicate? Are we going to provide the full report to everybody? Are we going to allow access to reviewing of the report, or are simply conclusions and consequences going to be reported? And once again, there are legal parameters on what you can and cannot do, but a lot of it depends on the policy and the procedures that you adopt. With respect to drafting, there are other things that you want to make sure that are in your policy, and that is what are consequences if there is found to be a proven allegation of sexual harassment. Well, then there's discipline, and a full range of discipline, which could include termination of employment for just cause. You want a strict prohibition on retaliation, and you also want a prohibition on false accusations. And this is where the policy drafting and the training for employees and supervisors comes together, because simply because someone has made an allegation of sexual harassment and been wrong does not mean it's a false allegation, a false accusation. Wrong is okay. It's where it is fabricated and malicious that it is a false accusation. And as Katie mentioned, in the drafting of sexual harassment, you're going to want to exclude certain things that aren't sexual harassment, like performance management. As mentioned, once you have your policy and procedures together, you need to do training, and you need to do 2 different types of training. You'll see we've got 2 different columns here. We've got training for managers and supervisors, And the training for managers and supervisors has to be more robust than the training for the employees. Not only do the managers and supervisors need to know the policy and know what it prohibits, but they have to know how to implement it. They have to know how to use it. Whereas employees, they also need to know how to access it. But when it comes to conducting investigations, making decisions, procedures, reporting, the employees aren't necessarily going to be engaged in those aspects of it. So you have to have a training and awareness training for your employees, and more of an implementation and administration training for your managers and supervisors. I'll also point out to you that some employers tend to think of policies as standalone, watertight compartments, which they are not. And so you have to think about your sexual harassment policy and how does that dovetail or interact with other policies in your workplace. So for example, many employers have computer use and device use policies. Well, those should also reference that those devices should not be used for any harassment in the workplace, and that the employer, there's a diminished expectation of privacy with respect to their use, and in investigating allegations under harassment, that those devices can be examined. Your code of conduct, you should deal clearly in your code of conduct that if traveling on business, if having company events, that sexual harassment policy is in full effect. As well as alcohol policies. Look at those, and oftentimes, in my experience, when there are instances of sexual harassment, they can arise on work trips where employees have traveled to a training seminar or to a presentation, and alcohol has been involved. So don't just think of sexual harassment as it's within its own policy, but what other policies do we need to cross-reference in order to make sure that we can adequately investigate these types of issues. One thing about Me Too, when you read about Me Too online and what it stands for, is it speaks of a very swift, consistent, immediate, and decisive enforcement of allegations of sexual harassment. And I would agree with that, but I caution that you also have to remember that both sides of an allegation of sexual harassment have legal rights. So the complainant has legal rights and the alleged respondent has legal rights. And rushing to judgment without doing a neutral and fair and thorough investigation can expose you to legal risk from the alleged respondent if you haven't properly investigated and properly done your fact finding. And also recognizing that having a policy that has a complaint procedure and has an investigation procedure does take some time. From the moment someone alleges sexual harassment in the workplace, there's a period of time where you're going to hear both sides of the story. You might need to consider other witnesses, and it does take some time. And part of the frustration on complainants and respondents is not having their expectations managed. And so what my advice is although Me Too is saying swift, consistent, immediate, decisive enforcement, I agree with that, but also remember to be neutral, fair, and thorough, and manage expectations and communicate time limits to those involved in this. Apart from training managers and supervisors to implement the policy, we also have to train managers and supervisors to monitor this in the workplace. The risks are simply too great to simply say, we're just going to train you how to deal with complaints. You don't want to train your managers and supervisors only to be reactive. You want to train them to be proactive. And so training them to be sensitive to signs and how to take corrective action. So when someone is presented with the sexting text message with a coworker or a photo or a comment that's made, to have managers and supervisors trained to say, hey, that's inappropriate, to deal with it then in a proactive way, as opposed to waiting for a formal complaint to build up over the years. And of course, training managers and supervisors to act involves many of these aspects, training them to take these matters seriously, to deal with them promptly, to deal with them sensitively, to deal with any complaint received and any complaint about which they learn, to follow the policy procedures, and to consider interim measures where appropriate, and to seek appropriate advice when needed. And that's one of the things is to remember that you're not expected to have all of the answers in the moment. And so if you're a manager or a supervisor and you need some time, then manage the expectations, schedule a follow-up meeting, get the advice and the answers that you need. Keep in mind that with respect that we've mentioned that these policies should clearly spell out what the consequences of breach are. And in serious cases, such consequences can be the termination of employment. And so we need to remember that to terminate someone's employment, we have to prove a reasonable a standard, but the just and reasonable cause standard. So that requires documentation, fair investigation, and proof that the person has engaged in the alleged wrongdoing. And then in determining what the appropriate disciplinary penalty is, there's a whole host of factors that go into the mix that we need to consider in determining, is this or is this not a terminable offense? We look at the nature and extent of the allegations, whether the person knew or ought to have known it was unwelcome, their prior record, whether it's an isolated pattern, their length of service, the violations of the policy, previous warnings, acknowledgement, remorse. And this is not an exhaustive list, but those are the types of things that we look to. One of the final pieces of advice I'd like to impart to you is the importance for managers and human resource professionals to document everything in this process. I have been involved in a number of cases over the years of sexual harassment, and I would say to you that the rare case is the isolated incident that just occurred. I mean, that can occur. There can be cases of sexual harassment which are a single isolated event which has just occurred. But in many of the cases, there's an escalating pattern that has occurred over time. And in some cases, one of the issues that arises is whether or not management knew about it 3 years ago, 2 years ago, 1 year ago, and did management sweep it under the rug? Did management address it? Did they deal with it? And so that's why it's important when we learn of these things to deal with them and to document them. So as these cases go on, if there's an allegation against the supervisor or someone of sexual harassment in the organization can say these issues have been addressed in the past. Because when it comes to legal liability, for example, I mentioned one of the trends is increasing cases of civil lawsuits. Different provinces have different statutes of limitation on sexual assault type cases. And in some provinces, there's kind of a bringing down of the limitations, the statute of limitations on those types of issues. So it may well be that you can be alleged or brought into a case of sexual assault from a long time ago. And similarly, with respect to human rights cases, if someone brings a case of sexual harassment to a Human Rights Commission, let's talk about Nova Scotia, for example. Nova Scotia has a 1-year limitation on complaints. However, there is an exception in the case law that if the complaint is part of a pattern or a continuing violation, then the person can link into those previous incidents. So all the more reason to make sure that when these matters are brought to our attention, if we address them and we address them in an informal way or we resolve them informally, that we still keep a record of it for our records to protect the organization should things happen down the road. So that concludes our presentation. I'm going to leave you with this very ominous slide, which black background with a, because I guess I would say that not only is time up on this webinar, but time is also up in the meaning of hashtag time's up. You know, the movement is continuing to move forward and quite appropriately. And as I've mentioned, you know, this is something that is many organizations are putting at the front of their risk management matrix to either develop better policies, develop better procedures if they don't have them already, or revisit and review their existing policies and procedures. So I'd like to thank you all for your time and attention today. And if you have questions, once again, we're going to stay around here for a little while and respond to the questions that have been asked of us on the and I'm just taking a look here. There's a couple of questions here that are more of an administrative nature, which we'll respond to offline, and we'll get you an email response. So thank you for your time.
Thank you very much for everyone for attending this morning.
And remember to